All right. Well, thank you, Donald. Again, I'm Lawrence VanDyke, and super happy to be moderating this panel because, as Donald talked about with the background I had, I wish I'd had this panel before I had my prior jobs because I could have really used a lot of the information I think we're going to learn about today. Our topic today is how, when, and why advance novel liability theories from a state and federal AG perspective. And we're joined today by wonderful and distinguished panelists. These panelists probably need no introduction, but that's not going to stop me from providing a short one. We've got former U.S. Attorney General Alberto Gonzales, and then we've got current Tennessee Attorney General Herbert Slatery with us today. So we should have a wonderful kind of mix of perspectives here. I'm going to just give a short biography for these, starting with Attorney General Gonzales. He served as the 80th United States Attorney General from 2005 to 2007. And before that, he had a number of impressive positions, including serving as a justice on the Texas Supreme Court and serving as general counsel to the governor of Texas and counsel to the President of the United States. And his current job is as the dean of the Belmont University School of Law. And Attorney General Slatery, as I mentioned, has been serving as the Attorney General for the state of Tennessee, right here where we're at, since October 1st, 2014. He was appointed by the Supreme Court. So in different ways of becoming state attorneys general, he was appointed by the Supreme Court. So that means he can't just get elected, but he actually must have some merit to have been appointed to serve an 8-year term. And in his current role, he oversees about 300 employees, over 300 employees across the state of Tennessee. And before this current job, he was the general counsel to Governor Bill Haslam from 2011 to 2014. And there's a whole lot more about both these men in your program, but I don't want to take up too much of the time talking about them. We're going to start with some opening remarks from General Gonzales, talking about our topic, and then we're going to follow that with a similar period of opening remarks from General Slatery. I'll ask him if they have any thoughts about each other's remarks, and then I'll ask questions, and I think you can provide or submit questions however it is that we've been submitting questions, and they're supposed to appear on this nice little tablet for me, so hopefully that all works. So take it away, General Gonzales.
Thank you. For those of you not from Nashville, welcome. I've been here since 2012, and it's been a great home to me and my family. Almost like being in Texas, quite frankly, but we're delighted to be here. I want to begin first by acknowledging my co-panelists, General Slatery. Herbert and I'd like to think we're good friends. I spoke to Don Cochran, who is the former U.S. Attorney here, about the relationship between the Department of Justice and General Slatery's office, and whether or not we in Tennessee benefit from the fact that the Attorney General of Tennessee is selected by the Supreme Court. Don Cochran told me that absolutely the citizens of Tennessee benefited from that. This was what he said, General Slatery. He says, because General Slatery doesn't make decisions or recommendations based on politics, he does always what is right. So I thought that was a good endorsement by Don Cochran, who I know very well, currently serves on our faculty. Today's topic, I think, is one that's interesting. I don't think it's one that can really be fully understood without having an idea about how decisions are made, at least at the Department of Justice. And this may be one of the questions, but in the event it's not, I just wanted to make sure that you all understood that many of the decisions relating to litigation, the Attorney General doesn't really have a say in it, quite frankly. Decisions regarding litigation are often handled within the divisions within the Department of Justice, oftentimes the civil division or the criminal division. And these separate divisions are supervised by an Associate Attorney General on the civil side, and the criminal side by the Deputy Attorney General. And every morning I would sit down at a staff meeting with both the Associate Attorney General and the Deputy Attorney General, and they would give me a briefing, sort of a status report about ongoing litigation, particularly significant litigation. We can talk about a little bit later about what I would classify as significant litigation. But as a general matter, these are individuals that are really, really smart, are oftentimes very experienced, and they're advised and counseled by career attorneys at the Department of Justice, and so decisions relating to litigation, oftentimes, I get a briefing, I may ask a few questions, and then I typically would take their recommendation. With respect to the only kind of cases in which I might ask more probing questions, or cases which I know are going to be important, significant to the White House, to the President, or if they affect the authority, the power of the executive branch or the presidency. In that case, I would probe probably a little bit deeper. But as a general matter, again, given this, you have 115, 120,000 employees at the Department of Justice. You've got a $25 to $30 billion budget. There's a lot going on. And as an organization, the Attorney General depends upon those individuals that are confirmed by the Senate. So their judgment is judged by members of the Senate in evaluating whether or not they can perform these jobs. And so, again, unless you're talking about a case that's going to generate a great deal of publicity, or it's one that's important to the White House, or it is a high priority for the Attorney General, a high priority for, say, a U.S. attorney, it's not something that I would typically weigh in on. So I just wanted to make sure that you understood that as we talk about these decisions and how they're made, the interaction between the Department of Justice and the state AG, that you have some understanding of that. So with that, I'll turn it over to General Slatery.
Well, thank you, Dean, Judge, General. He's got more titles than anybody I've ever met, but the most valuable to me was as a good friend. It was a great day in the state of Tennessee when Alberto Gonzales and Becky Gonzales moved to Tennessee. So I'll tell you that they're a treasure, and we're awful happy to have them. And if you should read the history of Belmont Law School and the difference that he's made and the fast track that they got on accreditation. So we're very proud of Belmont, but a lot of it's his efforts, believe me. Welcome to Tennessee. We're glad you're here. We hold the Scalia Law School in high regard here, and in fact, you're on the op-ed page of the Wall Street Journal today, awarding the award named after Justice Thomas to Judge Silberman. So, congratulations on that. I walked in today, and it's been a while since I've been in this hotel, but all these memories came flooding back. I was talking to my communications director, Samantha Fisher, as I was walking in, and this is where we had the transition meetings for Governor Haslam. So this was back in 2010. So this is where we spent, November and December in the cold months in these rooms up there with, this is back in the dark ages, sheets of paper with names on them and all the cabinets and stuff. So anyway, it's nice to be back. I'll just follow up on Dean Gonzalez's remarks. We operate very similarly, but on a completely different scale than the DOJ. So in Tennessee, it's already been mentioned, the AG is appointed by the Supreme Court Justice, and Luther Strange's successor, Steve Marshall, who's the AG in Alabama, always kids me and says, well, Herbert only has to get 5 votes. And I correct him, I say, really just 3. But it's been that way for 150 years. It's a great system, and it really is not much of a political office. I mean, you can't avoid politics, but it really is not much of a political office. But we've got 350 positions and a $50 million budget, 4 satellite offices. So it's much bigger office than I knew when I came over here. But the interesting thing is, and when I was first approached about applying for Attorney General, I had managed my private firm, and I sort of said, I've managed law firms before. I'm not so sure I want to do it again. And they said, well, think about it over the weekend and be sure and look at the organizational chart. So I did, and there's just one person up at the top of the organizational chart. So that answered some of my questions. And just flowing from that, all of the attorneys and staff in the Tennessee AG's office serve at the pleasure of the Attorney General. So there's a lot of control there, which I think is great, because if you're going to be judged, you ought to be judged on the people that you recruit. But I was fortunate because this has been a great office for decades. And I happen to be the first Republican AG since Reconstruction, but you look back and see the lawyers that were served as AG, and they've just been really fine lawyers. So when we deal with new causes of action, actually the Attorney General by statute and by common law has the right to pull the trigger on that. So I sign every complaint, and I actually delegated that to one time, and that was last week, to somebody else because I knew some of the parties involved in the lawsuit. But probably the biggest lawsuit that we've been involved with, and most complex, has been the opioids multi-state investigation and the litigation surrounding that. And I think it was back in early 2016, some of my really good lawyers, some of whom are here, walked in my office and said, "Can we join the opioid multi-state investigation?" And I had no idea what I was doing when I said yes to that. Believe me, it has ended up to be the most complex civil litigation, and I think in our country's history, at least to my knowledge. It's the Purdue Pharma's bankruptcy, which I assume Luther has already mentioned, but he has been involved in that. That's the most complicated bankruptcy case according to the bankruptcy judge, and it certainly had the most claims ever filed, and the states alone filed $2 trillion worth of claims. Tennessee, what we did, we really had sort of a multi-pronged approach to it. We were one of, really I think initially it was 7 states that led the multi-state investigation and the negotiations with the manufacturers and 3 distributors. And we expanded that near the end because we needed more consensus and actually needed more help, but to around 14 states. And Tennessee, so we were involved in a multi-state investigation of the distributors, but we also filed 4 lawsuits, against 2 manufacturers and 3 distributors. And and you all have talked, I believe you've already spoken a little bit about some of the claims, but our claims were a public nuisance, both common law nuisance and statutory nuisance. And the real key to that was, in Tennessee, and we've got a 1975 case that's very, very broad for nuisance purposes. It says basically that a nuisance endangers public health or public safety on an ongoing basis. So it's pretty easy it's pretty broad, and actually, so we relied upon that, and we've sued under the Tennessee Consumer Protection Act. We also had, in one of our lawsuits, we filed a civil RICO claim, and our aim there was to get at the revocation of the license of the distributor that we filed the case against. We wanted to revoke their license for what they did here in Tennessee. And I'll just end with this. In Tennessee, especially Northeast Tennessee and that Appalachian corridor, and I think Virginia and West Virginia will confirm this, probably ground zero for the opioid epidemic. The better part of a generation has been lost up there, and it has not abated since COVID. In fact, last year we set a record. We had 3,000 overdose deaths. 2,300 of them were opioid related. That works out to about 7 people a day dying, and that is the one issue that was really difficult to deal with, because we've got 3,500 plus cases up in the multi-district litigation in Cleveland. We've got our own lawsuits, and then we've got the multi-state litigation that we were leading with 40 plus states. And the more we delayed, and particularly delaying on arguing over attorney fees, it was really, really difficult because every day we argued over attorney fees. It wasn't like some business losing money or anything. It was 7 people died. And I know in Florida it was 14, and I don't tell me what it was in California. So that was a separator in my mind, because that really weighed on me that we didn't have any money to try to help these people. And now a lot of things have changed. The prescriptions have gone down. We know drug courts work. They've expanded, and we're going to hopefully get some funds here shortly to finance other programs and rehab facilities and things like that. So, and the big part of that's going to come from a $26 billion settlement that we had with the 3 distributors and Johnson & Johnson. So, in any event, that gives you an idea of the most complex things and how we got into that. But we can go forward from here. Will Rogers says, never miss a good chance to shut up, so I think I'll do that.
Well, my job is to try to keep you both talking, so
Oh my goodness.
the question I've got is, particularly in the federal DOJ, just because it's so big, but also in state DOJs also. There's been a lot of emphasis, understandably, on things like opioids and tobacco litigation, and obviously something that big is going to have a lot of thought given to what kind of arguments are going to be made, et cetera, and probably get a lot of managerial review from the very top levels of the state or the federal DOJ offices. But when we're talking about novel liability theories, particularly in this huge federal government, I had a stint at DOJ, and I think the thing I took away from it was, man, this place is big, right? There's just so many people for every little topic, and it occurs to me that how do you try to police or make sure that a lot of liability theories, particularly I oversaw a group of about 80 trial lawyers, and I was a political appointee, but I'd get a report, I'd get this probably a similar report to what you get, but just like further down the chain, and it was only a small portion of all the cases that they're doing. And some of them were cases where the federal government was actually bringing the action. But many of them were cases where we were on the defensive side. Both of those implicate novel liability theories, because people bringing the lawsuits against the government, and this is true for state offices too. But the question I've got is, how do you keep from these novel liability theories from just sort of happening organically in organizations that are as big as obviously the federal government, but also most state governments, so that you actually are giving some thought to whether or not, so these things, not for opioids, not for the really big cases that we all read about, but for, in many other areas, how do we control and police and make sure that the arguments that the line lawyers are making are
not wacky.
Yeah, and being picked up by courts, et cetera.
Well, of course, decisions regarding litigation, in my judgment, always depend upon several factors. Priorities, resources being 2 very important. And so I used to make sure my lawyers understood, and I don't know how far down the message got, of course, at the department, and that is that our job is to protect the public good. That is our job. And if you're winning all your cases and you're not prosecuting or litigating enough cases, sometimes you have to be innovative. Sometimes you have to be creative, and there's nothing wrong with that. Losing a case when it's in the pursuit of the public good was something that I was always very supportive, and I knew that President Bush felt the same way. I'm not going to, at my level, I'm not going to hear about these novel theories that some people may think are just crazy. And you know what? Sometimes crazy ideas turn out to be the right ideas. And so I think we need to be careful about discouraging people to think outside the box, because sometimes that's what it takes to be successful in protecting the public good. So that's how I would respond to your question about making sure we don't go off the rails and we're not too crazy. But again, as I said earlier, sometimes being creative and innovative is is absolutely the right thing to do. And you have to have confidence in the people that work for you, people like yourselves in the Environmental and Natural Resources Division, that you've got the right judgment so that when your lawyers come to you with something that's never been heard of or tried before, you think, well, you know what, that may just work. And so you give it a shot.
So General Slatery, and your office, I think, sounds like it's similar to the size of the Nevada Attorney General's office, and there, is it different in the sense that there's a little more ability to sort of have some visibility about all the different things that are going on? There's still some stuff that's kind of slips through the cracks, or what's it like in the state AG's office?
Well, I think the most important thing to do is hire the right kind of people, and be sure that you've got the right kind of people in the appropriate positions. And I've really tried to hire people a lot smarter than I am, and so they'll catch a lot of these things. But as we evaluate those types, we're open to ideas, and to new thoughts. But we do a lot of work, especially on the significant cases, and ours is primarily civil at the trial level. We don't have any original criminal jurisdiction. So, but I want to know, is it fact-based? And that's why we use CIDs, which maybe some of the judges aren't familiar with this, but we use the civil investigative demands to get testimony, data, documents, and then we coordinate that with other states. So we have a good factual package of what we understand to be the problem and the parameters of it. And then we ask the question, how does it affect Tennessee? Because to me, it really has to adversely affect Tennessee to move forward on it. And then, as we go through the different theories, we're asking, I like to quote Stephen Covey and say, you begin with the end in mind. What remedy are you looking for? And that's a really good question, because it's easy to go to monetary damages, but frankly, a lot of our value is bringing in injunctive terms, and we want to be sure to incorporate those. And so we go through that list, and then and if there are new theories, I'm thinking, can I explain that to somebody? And also, is it based in fact, or we just try to paint something over it? If we need to have a substantial basis for what we're doing.
So, sort of related to the last question, it occurs to me, having worked in a couple state AG's offices and also working in the Department of Justice, you could say that those institutions sort of have a conservative bias, not in a political sense, but a conservative sort of risk-adverse bias in the sense of your average person. I think of the Federal Solicitor General's office, brilliant, some of the most brilliant lawyers there are, but they wouldn't normally be the kind of people that are going to get jazzed about the latest, greatest liability theory or something, and so I wonder.
Yeah, because they'd have to sell it to the Supreme Court.
Right, so
it's just
and this is true in state Solicitor General offices, which play a similar role. So there's been some talk today on some of the other panels about this state versus private divide on things like opioid and just various areas where you would maybe pushing where there's being novel liabilities promoted or pushed. Do you think that there's in either the federal government or state governments, do you think that there's that maybe institutionally there's any challenges with them having just more conservative bias towards being when I think in business, you think of entrepreneurial people, and then you think of people that are great at managing an already established business. And if I was to put the federal and state governments in one of those boxes, it would be more of the established business running the business. And so maybe they don't have that entrepreneurial bent that your typical plaintiff's lawyer would have towards a novel liability theory. Any thoughts on that? Or?
I would say that I think it's possible you would find lower court judges who might be receptive to something that's novel, because they think, well, if I've got this wrong, the Supreme Court will take care of it, will fix it. So maybe they might be receptive to something like that. But I think as a general matter, I think saying that it's more conservative, I think is probably accurate. But you may find outliers out there that might be willing to listen to a novel argument that's never been presented before.
A twist on that is while the institutions themselves or our offices may be more conservative, I think you're right about that. Some AGs have hired outside counsel on novel theories and let them run with that for a while. We've been involved with the state of Mississippi for, I think, 14 years on a lawsuit over water rights down in Memphis. Take that back. Tennessee hasn't been involved with them for that long, but Memphis and Memphis Light, Gas, and Water, the utilities, have been involved. And their novel theory was that they owned the water in this aquifer that spans 7 states, and therefore Tennessee owes them $615 million plus. Well, that's a novel idea, but.
I think former General Hood may be here somewhere. So
I hope he is. But that's an example where we hope the Supreme Court does correct them. But we've been up there twice, and that is not how you define water rights. That's equitable apportionment, and that's the long line of cases. But this aquifer is, the issue is whether it's interstate or intrastate, and that's gone all the way up to the Supreme Court.
Yeah, so I guess a related question, and this will kind of lead us, I think, nicely into some maybe differences between state and federal government, federalism issues, is in my experience with the federal government, it's just so big and it's very siloed. So every job is detailed, and you got lots of people in each division. Whereas, having worked in one of the smaller states, population-wise, in Montana, and then Nevada's not exactly Texas or New York or California, you end up wearing multiple hats, it feels like, a little bit more in the state's offices sometimes. And so I wonder if there's a difference that's sort of similar to the difference I was talking about between perhaps private lawyers versus government lawyers generally, as far as institutional, call it risk aversion, call it creativity. Is there a difference maybe between working in state government, state AG's offices versus being the quintessential federal lawyer, as far as your willingness to promote novel liability theories? General Gonzales, you worked as a state Supreme Court justice, so you had the state lawyers arguing to you, and then you, of course, were at the Department of Justice.
We were pretty conservative.
On both, yeah,
on the court level, no question about it. I don't know if I would say there's a difference in terms of creativity between the lawyers at the state level and the federal level. I really don't. I don't think there is a difference.
What do you think, General Slatery? And because I'm thinking, as a Solicitor General of Nevada, unlike in the federal Solicitor General's office, where basically your job is to police all of the appeals and the Supreme Court advocacy, we also wore the hat of suing the federal government at certain times, right? And so that's a very different hat. Suddenly you're putting on the creative plaintiff's lawyer's hat, and I don't know so it seemed like in the federal government you'd have those people, but they'd be in a different area. So I didn't know if you had any experience with that.
Well, that's probably the issue that we watch the most, is the federalism issue and the encroachment upon 10th Amendment rights by the federal government. Frankly, we joined a letter of about 20 attorneys general last week and sent it to the attorney general, objecting to the possibility of FBI agents attending school board meetings. And I think, I don't know whether creative is the word as much as we are ever watching, because that's the most important thing, I think, from our states as far as the federal government is preserving our authority and the jurisdiction that we have, and especially on education efforts. Senator Lamar Alexander, who recently retired, is well respected here, was former governor. He used to say all the time, we don't need a national school board, and we really believe that. We've had the DOJ come in and investigate, school boards down here, and we oppose that, and we'll oppose it at every opportunity.
I really also agreed and appreciated the letter that you signed on to with respect to voting rights. Mm-hmm. And the passage of the John Lewis Act, which of course was a great American. But I think states were intended to run elections.
I do too.
And unless there are violations of fundamental rights under the Constitution, then states should be free to run elections.
Yeah.
Well, that's a good transition to, I do want to talk a little bit about how, in a moment, about how state AG's offices and Department of Justice can kind of collaborate sometimes, federal, and also, you know, obviously they're at war sometimes, and it'd be interesting to hear both of your perspectives on that. But before we do that, I did get a question from the audience I think is a little, maybe a question we should ask before that, because it kind of relates to some of the earlier questions I asked about how do you police novel theories. And one of the questions was, you know, when you have these qui tam actions or private attorneys general type actions, how do the state or the federal government police those novel theories raised in those actions to make sure that, you know, you're not getting novel theories in the courts that really the state, I mean, I can imagine even putting politics aside, you might just be like, this is a great argument for this case, but it's a terrible argument for the state, you know.
Well, on key times, I think that's really true. You know, a lot of times you've got the relator who brings the lawsuit, and then are we going to intervene? Is DOJ going to intervene? And I think that's one area where we work pretty well with them in our Medicaid fraud area, and have the same objective and goal. And but even those, there are some cases that we pass on for that reason. We're sitting there thinking, really, you know, and it's just like Dean Gonzales said, you know, you got to think about resources and how much you can put into it, and what the amount is, and you know how grievous it is the action, those types of things. And so we think through those things, but we've got a really good relationship with the U.S. attorneys here in Tennessee on that particular issue.
So how much, you know, it seems like in qui tam you've got where the state comes in and shuts it down, right? And that happens sometimes. Mm-hmm. You've got the cases though where the state basically says we don't want it, or they come in and they take it over, right? Mm-hmm. And those send a pretty strong signal, I would think, to the courts. Mm-hmm. Then you've got those cases where the state doesn't take it over, doesn't shut it down, but just lets it go. Right. What should courts read into that? You know, the state didn't have the time to look at it closely, or have made any kind of judgment. What should they read into it?
Well, I would think that, you know, for us, it would be we would sit there and weigh the factors. You know, how egregious was the conduct? How much was our TennCare is our Medicaid arm, and so how much damage was involved, and how widespread. You know, if you've got one clinic or one doctor. Is it across the state, or you know, are your DRGs? Are you arguing over that? You know, and a coding issue that would affect so much. And if it's broad, then we're pretty interested in it. But at the same time, you know, we've got budgetary constraints. You know, like the federal government, we have to balance our budget here in Tennessee. So it becomes a resource issue too, so that it should, as judges, you know, sort of keep that in the back of your mind. There are only so many things that we can take on, so it doesn't mean that the claim is wrong. It just may be that it's a resource issue.
Maybe not.
Other priorities. And by the way, Don did say that with respect to qui tam issues and medical fraud issues, that he thought the level of cooperation with your office was very, very strong.
And that's something that's changed since I've been in office. We've actually, you know, beefed up that area and hired different people, and there's a new deputy who worked for a large healthcare insurer. So we've got a lot more expertise than we used to have.
So talking a little bit about the interplay, moving to like the interplay between the state and federal governments. Let's start with the positive, I guess. So what are some examples, if you can think of good relationships between state and state AG's offices and the Department of Justice on, you know, taking on some issue, litigating it together, mm-hmm. maybe one side or the other taking the lead, but.
Well, for us, you know, the big area is antitrust. We work with them significantly on that, and we're heavily involved with. We're involved in 3 lawsuits against the tech companies. So, and DOJ's been involved with all of that. We actually consulted with them before we brought the action, just to vet theories and discuss and that sort of thing. And then I think the social media platforms are another area. Here's one that's really interesting that nobody in here would predict, but Don Cochran, who's a good friend, he's mentioned him, called me one day and said, I need some more positions over here to ramp things up on a prosecution basis. And I said, well, that's good. He says, the only thing is I can't get the positions out of the federal government. I said, well, that's okay. He says, but there's this grant program that if you hire them and put them in my office, then it works. And I said, oh yeah, really? So I'm hiring somebody that I don't supervise, and I pay, but I'm dependent on getting the money from the federal government. Well, he talked me into it.
I was going to say, this is. I think Bill Maher had this program where, yes, he would allow Don Cochran, any U.S. attorney, to hire an additional prosecutor if it was provided by the state.
And we needed it, and in Middle Tennessee, we did need more prosecutors, so we went along with it. But every time I get an email from, I forget the name of the federal agency, I look at it and just roll my eyes.
Huh. Well, do you have any, during your tenure as attorney, do you remember any great collaboration?
It's been like 8 years since, so no doubt. But I don't recall hearing complaints about the level of cooperation, although, that's not really true now that I think about it. What I found is that where you have politically state elected AGs is oftentimes we would butt heads in terms of cooperation, particularly if the state AG was of a different party than the president, for example, because there are politics that get involved.
Yeah.
And that's unfortunate, but there were instances when that occurred.
And in my experience, when we were suing the federal government, and then the administration changed, even then, you'd think suddenly, okay, now we're both my boss and their boss are all on the same side. We should be kumbaya. But it turns out there's a lot of institutional considerations for the federal government that make even those sort of relationships kind of challenging sometimes. So we'll turn to the other side of it, the dark side of it. So what the warring between what we call federalism, I guess. It's first of all, I guess, any thoughts on there's competition, there's faction, whatever you want to call it, between the states and the federal government in various areas. Do you think just generally that's a good thing? Do you think we're getting more, some people think we're getting more of it, that it's a bad trend? On the other hand, it's part of our constitutional design, right, to have federalism and have competition between the two different parts of our government. Any thoughts?
I don't know if I would call it competition. Never felt we were in competition with the states. We may have a disagreement about who should be the lead, who should handle a particular issue, but I don't think I would characterize it. Herbert, what do you think? Competition?
I would agree. On some issues, one of the defining things in my mind is if you've got bipartisan coalition at the state level, working with the DOJ or even against it, that says something. If you've got bipartisan cooperation, and we do have that on the tech platforms, on opioids and things like that. So I think there's a lot of cooperation there. Where we have issues is frankly when the executive branch decides they want to change the law. And so they issue an executive order or an executive director, or they'll issue a guidance letter or whatever. And, that's, the separation of powers is a really important issue. And I know Congress, they don't get much done these days. And so that puts the pressure on the executive branch to get things, to solve problems. But it's that overreaching that causes us, some concern. So that we're watching that in, like we mentioned, voting areas. We challenged back in 2014. We challenged DAPA in the immigration area because it had an executive order and executive directive that, frankly, granted rights, and we'd never seen a prosecutor, be able to grant rights, and so we filed an action against that. So we're watching it all the time, but there's cooperation here, and then there's when you start dealing with constitutional grounds and changing the law and how you do that, and do you ignore the APA in doing that? Well, that's a red flag for us. In fact, I remember on that DAPA case, I remember being up at NAG and National Association of Attorneys General, and they have a Supreme Court review, and I was listening to the experts saying how we were going to lose that case, and of course I didn't really, that wasn't well received, but the Fifth Circuit sure liked our argument, and the Supreme Court wanted to hear about it, and eventually it was dropped. But it was that issue of how do you change law? Do you do that by legislation, or do you do it by executive order and directive?
Well, I'm not going to defend that particular executive order, but I will say, as someone who worked in the White House, that the way it works, at least it was when I was in the White House, is that before the president can issue an executive order, the Department of Justice has to sign off on it in terms of form and legality. It's consistent with existing law. That executive order cannot override an existing statute. This represents the way the president interprets existing law, how the president's going to enforce existing law. That's the purpose of an executive order. But I understand how some people will say, well, that interpretation completely rewrites the statute, and therefore we think that the president is overreaching.
So that's kind of what I think I meant by a competition, in the sense of, it does seem like, at least you hear this a lot, that there's a lot more litigation, regardless of the who's in the White House. It just switches basically, and then we have these coalitions of states that are suing, and so in a sense it's obviously a partisan phenomenon, but it's a bipartisan phenomenon in the sense that you get it either way. And so do you think that this development of where the states have basically taken it upon themselves, it seems like, when I use the word competition, but basically to push back on what they perceive to be excesses, overreaching, or whatever, without taking position on any of those, whether or not they actually are or not, but the states have kind of put themselves in that role as one of the primary drivers, these coalitions of states. Is that a good development? Is that federalism in action? Is that a bad development? Any thoughts on that?
I think it's a good development, quite frankly. And at the federal level, I think I would welcome it, because the framers did intend for the federal government to have limited power. The power is supposed to reside at the state and local level, and so I would view that as simply the states doing their job.
I think it's healthy. My only reservation would be, and this cuts both ways too, is I'm not so sure about nationwide injunctions, and we have supported those, and we have opposed them too. So it's I'm not the only one raising that question. So
yeah, I agree with that. It doesn't seem right, doesn't feel right that you'd have a nationwide injunction, but.
Well, let me ask the question about that specifically to our topic here, because nationwide injunction oftentimes there's a novel theory being presented in favor of a nationwide injunction, or at least some people think it's a novel theory, and you get one court, one judge essentially buys into that, and now it's basically the law for the entire nation. So how has that affected, instead of having these novel theories sort of percolate, when we talked earlier about, I think General Gonzales said, I think he's right, that you kind of you don't want to disincentivize your lawyers from making creative arguments and doing good lawyering, right? But part of the way I think the system works is those arguments might be adopted by one court, right? And then that'll sort of get percolated in the SG's offices, in the Attorney General's offices, in the executive branch, and the appellate courts will sort of sort through all that and be like, oh, that's a bridge too far. But when we have these nationwide injunctions, you could argue that the problem is everything gets kind of locked down at that first level. So any thoughts about that, and if there's any sort of, any remedy. Can you guys solve the nationwide injunction problem right here? This slide.
You've hit the issue. I mean, it's so broad, and face it, we all forum shop. I mean, we decide where we're going to file cases for reasons, and it's that's just part of the analysis. That have somebody in whatever state actually shutting something down in your state, sort of. It's difficult. Of course, if you're for the injunction, you think it's wonderful, but if you're not, so.
Well, that saying that if you're the smartest person in the room, you're in the wrong room.
Yeah.
Perhaps there's someone in this room that has a solution to your question. I don't know.
All right. I'm pretty much out of questions that I presented, and the questions folks have been asking have been the same. I feel like I must have predicted pretty well, because the questions that people have been asking. We've got about 5 minutes left if anybody has an additional question. Otherwise, I guess we could probably just quit early and everybody will be really happy with us, so we'll have no extra time.
We've got work to do.
Yeah. Well, I really do appreciate the panel has been, this is just a great panel. It's great to hear about how what the various offices have done, and obviously I think if you're a judge in the room and you haven't had the experience of working in either state or federal government, feel free to, I guess, ask these gentlemen about more questions, because I think it really does give a helpful perspective on how these theories tend to develop. I will say the one other thing I'll say that I think it was implicit in especially what General Gonzales was saying and also what General Slatery was saying. These institutions do have built into them mechanisms. We have the Solicitor General's office is in it to try to make sure that these theories get sort of sorted out, not necessarily always at the trial court level, as we talked about. So maybe that's an issue with the nationwide injunctions that should be explored more, is that those things can there's not a lot of policing of that at that level. But as they do go further up, I remember when I was working it was frustrating as somebody who worked in a division in the Department of Justice. The Solicitor General's office had a real lock on whether or not you could raise arguments, and they were very conservative in a sense that like you might have a argument that's not a bad argument for getting something overturned, but they still didn't want to let you raise it just because I think they were just very conservative in that sense, and that's probably a good thing. I think that's probably a good thing.
You raised the Solicitor General's office. That's a really key office in our operation, and Sarah Campbell's here. She's Associate Solicitor General. But one of the things we did early on was if it's a significant case, then they're involved because they want to create the proper record. And so, you think it might be, well, do what you want to at the trial level, but when it gets to Solicitor Generals, they're going to take the appellate. Well, that record's really key. So we've learned to bring them in early on. So on the major pieces of litigation, they know what's going on, and they have vetted the issues, which has really benefited us, I think, and it's just another filter. So we rely upon them very heavily. In fact, I think that's one of the downsides of COVID, because I'll walk into Sarah's office and say, "What do you think about this?" Or I'll walk into General Blumstein's office and say, they won't file this complaint this way. What do you think? And I miss that. In Zoom meetings or Teams or whatever. You can't replace that. So I was going to start out saying, "Well, this is really unusual, an in-person meeting. This is really cool."
From my perspective, involving the SG, obviously after 9/11. The president had to make some very difficult, novel decisions that we'd not confronted since World War II. And so sometimes even before some of those decisions were executed, we'd have conversations with Ted Olson, the Solicitor General, about, okay, how's the court going to react to this? And sometimes he got it right, sometimes he got it wrong. You just can't, it's just hard to predict sometimes. But I think I agree with General Slatery. Involving the SG's office sooner as opposed to later is very important when you're talking about novel issues or potentially controversial questions.
Well, Sarah, this is my whole goal here, was to bring it back to the SG's offices. So on that note, I think thank you very much for wonderful discussion.
Thank you for having
and,
us. Thank you.